Minister.
Madam Speaker, I present a bill titled Fines and Penalties Recovery Amendment Validation Bill 2024, Serial 8.
The Clerk.
A bill for an Act to amend the Fines and Penalties Recovery Act 2001.
Minister.
Madam Speaker, I move the bill now be read a second time. Madam Speaker, I present a bill entitled the Fines and Penalties Recovery Amendment Validation Bill 2024. The purpose of this bill is to retrospectively validate enforcement orders and subsequent enforcement action made under the Fines and Penalties Recovery Act 2001. This Act provides for the recovery of monies payable to the Territory arising from penalties imposed by infringement notices and fines imposed by the court as a penalty during court proceedings. Infringement notices are used where there is a penalty which may be imposed under an infringement offence. These notices are issued by various enforcement agencies, including NT Police for speeding offences and other offences where an infringement may be issued, councils for parking offences and other infringement offences, and agencies such as the Department of Health, which may undertake regulatory enforcement actions through the issue of an infringement notice. The Fines Recovery Unit operates to enforce the payment of these fines and penalties. Where a penalty imposed through an infringement notice or a fine issued by a court has not been paid within the required time frame, the penalty or fine becomes a debt payable to the Territory. It may then be enforced by the Fines Recovery Unit unless the person to whom the infringement notice has been issued has elected to have the matter heard by a court, or, for a fine, the person has applied for a rehearing or lodged a notice of appeal against the conviction or sentence. The way the Fines Recovery Unit enforces unpaid fines and penalties is by making of a fine enforcement order or a penalty enforcement order. This allows the Fines Recovery Unit to take further action under the Act, known as the taking of sanctions, which includes actions such as suspending driver's licences or naming and shaming a person with unpaid fines and penalties, to encourage payment of the fine or the penalty. These sanctions are commonly used across Australia by bodies like the Fines Recovery Unit to recover unpaid fines and penalties, and are necessary to uphold a robust infringement and penalty regime. However, in June 2024, a number of issues were identified with the processes applied by the Fines Recovery Unit in enforcing unpaid fines and penalties. The Fines Recovery Unit has temporarily ceased undertaking enforcement action whilst it works to address these issues. This bill is the first part of that work, so that the Fines Recovery Unit can recommence its function to enforce and recover unpaid fines and penalties. Madam Speaker, this bill seeks to validate the purported enforcement orders made in good faith by the Fines Recovery Unit. It also seeks to validate all subsequent enforcement action taken by the Fines Recovery Unit in reliance on these enforcement orders, seeking to comply with their lawful obligations to recover monies payable to the Territory. The validation is made to all enforcement orders and enforcement action taken up to the 28th of June 2024 as the date on which the Fines Recovery Unit ceased taking action. It does this through inserting provisions into the Act to validate penalty enforcement orders purportedly made, validate fine enforcement orders purportedly made, validate the subsequent enforcement actions taken on the purported enforcement orders, and provide that enforcement action taken by the Fines Recovery Unit in the name of the Registrar of Motor Vehicles is deemed to be validly performed. The measures to validate the orders are necessary to ensure that the actions taken by the Fines Recovery Unit to enforce and recover fines and penalties are not invalid because of errors in the application of the enforcement process. As I indicated, the Fines Recovery Unit was operating to enforce and recover unpaid fines and penalties that had become debts payable to the Territory. This is not about the issue of the fines and penalties themselves, which are valid, but of the enforcement and recovery of unpaid fines and penalties that were a debt to the Territory. the Fines Recovery Unit took steps in good faith to enforce and recover the unpaid fines and penalties. This bill forms the first tranche of amendments seeking to improve the enhancement processes implemented by the Fines Recovery Unit under the Act. A further bill will seek to make amendments that will follow the Fines Recovery Unit to recommence enforcement actions and will reduce the administrative burdens currently placed on the Fines Recovery Unit in undertaking enforcement actions. I am pleased to commend this bill to the House and table a copy of the explanatory statement.
Sadly, there's no one to adjourn the debate from
Perhaps
the opposition.
Perhaps I'll move it.
Leader of Government Business.
I move that debate be adjourned.
The question is that the debate be adjourned. Those of that opinion say aye. To the contrary, no. I think the ayes have it.